Welcome back to the Dershow. Yesterday, I planned today's show, and I planned to make it about the Fox lawsuit against Dominion lawsuit against Fox, and I thought it would be the first day of trial. We'd have something to report upon. Well, we do have something to report upon, but it's not the first day of trial. The judge, without indicating any reason, said the trial would be postponed one day. I immediately knew what the reason was, and I think so did most other people. There are settlement talks going on, and there may not be any resolution of the case. There may be a settlement. I think that would be too bad in some ways because this is a case that involves very, very important First Amendment principles. It's the mirror image, in many ways, of the lawsuit I brought against CNN. Raises similar questions, conflicts between the First Amendment and the law of defamation. So let's focus on the Fox case, but I'll be mentioning my case too, because obviously I have to make full disclosure that I have a case, and my case could be impacted in some way by the Fox case. It already has been in some respects. So the Fox case is not simple. It involves Fox News, which, as you know, is a conservative, widely watched um, uh, platform, network that has many commentators. I've been on it often. I've been on Hannity frequently. I've been on Tucker Carlson. I've been on Maria Bartiromo's show and others, Mark Levin and others. I've also been over the years on many, many, many more shows at CNN, but CNN has now canceled me and banned me along with MSNBC once I defended President Trump on the floor of the Senate. The so-called liberal networks, the ones who believe in diversity, don't believe in diversity of points of view. So no longer could I be on their shows. No longer can I write op-eds for the New York Times. I'm now relegated to the Wall Street Journal, which I love. I enjoy writing my op-eds for the Wall Street Journal. But don't let the left ever fool you when it talks about diversity. This is the last thing the left ever wants is diversity. Very few people, left or right, want diversity. They use the word diversity to say more of me, more of mine, more of my kind, more people of my color, more people of my religion, more people of my race, more people of my political persuasion. That's diversity. About as many people want diversity as really want free speech. Most people, again, want free speech for me, but not for thee, and they're perfectly happy to censor their opponents. So, what's at issue in the Fox case? Fox had on its program a number of people, including some of Trump's lawyers and people close to Trump, who claimed that the 2020 election was stolen. Millions of Americans believed that. I think they were wrong. I don't think the election was stolen. I think the election was reasonably fair. I had some criticisms, particularly in Pennsylvania, which I think violated Article 2 of the Constitution. But the result of the national election would not have been different. So I don't believe that the election was stolen, but I do not only believe, I know for a fact that millions of Americans think the election was stolen. They're wrong in my view, but they have a right under the First Amendment to express their views. They also have a right under the First Amendment to hear people who express views similar to them. If the same people had been on social networks, on Facebook or on Twitter or on YouTube, um, those platforms couldn't be sued. There is a special provision of law which exempts social media and internet companies from being sued for defamation based on what's on their platform because they don't really control what's on their platform. People can post it immediately. They don't take it down. That may be their responsibility, but putting it up in the first place is different when you have internet than when you have Fox News. Fox News calls me and says, "We'd like you to be a guest on Hannity." They don't ask me what my views are, and I wouldn't essentially ever change my views to be on a television show. And they may have some idea what my views are, and on certain subjects they might be right, and others they might be wrong. I've surprised people a lot on networks with my points of view, but the point I'm making now is that there's a difference in the law between a network and social media. Social media could not be subject to the same kind of suit that Fox is being subject to for over $1 billion. Now, the absurdity of $1 billion lawsuit, Dominion hasn't I can't imagine they've lost anything over this. They probably gained a lot, but they certainly haven't lost $1 billion. Now, I have one pet gripe about Dominion and about Smartmatic and about these other companies, and I'm involved in some lawsuits that manifest that gripe. And here's what it is: when the government delegates to a private company a function that is generally governmental, and what could be more of a governmental function than counting votes from the beginning of time, when George Washington's votes were counted and Adams' votes were counted and Jefferson and Burr tied. From the time of the beginning of our republic, government agencies have counted votes, that usually by hand, usually by paper ballots. But now governments in all the states virtually, and certainly in the federal government, have delegated that responsibility, that government responsibility, to private companies. But private companies are not acting like the government. They're acting like private companies. They're saying, oh, no, you can't look at our algorithms. You can't look at our machines. You can't examine how we count the votes. No, that's business privacy. That's our intellectual property. You can't look at that. No. You can't perform a government function and act like a private corporation. If you're going to get paid, and these companies get paid fortunes of money, if you're going to get paid to perform a governmental function, counting votes, you darn well have to be willing to open your books. You have to be willing to be transparent. You have to be willing to let Fox's experts or experts from other people. I've represented Mr. Lindell, and he's involved in suits of this kind too. You have to be willing to let these folks look at the insides of your machines. If you claim they're lying about you, then you have to demonstrate that, or at least allow them to demonstrate it if you think the burden of proof is on them. The idea that you can hide your mechanisms, your algorithms, etc., from public scrutiny, while at the same time claiming, oh, I did everything right. There was no possibility that anybody could have hacked my machines. Are you kidding? My machines are hack-proof. Well, maybe they are. If they are, what do you have to hide? Let the experts look at it. Let them have non-disclosure agreements about certain specific aspects of it, but let them at least give the court an evaluation. Now, the court in this case, in the Fox case, made a decision. It looked at the evidence in clear violation of the 7th Amendment to the Constitution. It looked at the evidence and said the evidence conclusively establishes that it's crystal clear that these machines did not produce the wrong result. Well, that's not the judge's function. That's the jury's function. And if the judge is going to make that decision, then it should be made only after experts have had an opportunity to examine. The judge's decision here is just an ipsy-dixit. It's right because I said it. I haven't seen the evidence that would support that. And again, the 7th Amendment says basically that any issue that under common law was tried by a jury should be tried by a jury, not by a judge. And a judge should not be able to re-evaluate the facts as found by juries. And here the judge took that issue away from the jury. That may be why the cases looked like it may be moving toward settlement, because the judge has taken away some of the most important issues. But even more profound than the issue of whether or not there should be discovery about the inner workings of the machines is the question of, and this is a fundamental First Amendment question, and I hope it gets resolved, should a network be permitted to put on the air people who take a view different from the view of the network itself? Now, we know from the emails that the people, remember, there's no such thing as Fox. Fox is Murdoch and then bunches of people below him. Decisions aren't made by corporations. My first piece, the piece that made the editor-in-chief of the Yale Law Journal, was about corporations and about how corporations aren't humans and they don't make decisions. But the Supreme Court has said that corporations have First Amendment rights, mistakenly, I think, but they have. And the question then is, what if Murdoch said, look, I believe the election was fair, and what if Hannity said, I think the election was fair, and Tucker Carlson said, I think the election is fair, and Maria Bartiromo said the election is fair, but I'm going to allow somebody to be on my show who said that the election was stolen, because there are millions of people out there who believe it was stolen. And I want to give them a voice. I want them to have an opportunity to hear from a point of view that's different from my own. Is that permissible under the First Amendment? That's the key issue in this case. And in one respect, I hope it goes to trial because that key issue is very important. It's very different from the issue in my case. So in my case, I am suing CNN, as you know, and CNN just totally distorted what I said. I said a president can be impeached if he commits treason, bribery, or other high crimes and misdemeanors, or if he commits criminal type behavior. A president can be impeached. But the commentators on CNN said Dershowitz as a president can't be impeached, even if he commits crimes, even if he commits murder, even if he commits the most horrible, serious crimes. And the judge in my case found as a fact, of course, this is a quote, of course, Dershowitz said nothing of the kind. Nothing. Of course, I said nothing of the kind. You can see it on videos. And then the judge accused CNN of, it says, the evidence establishes foolishness on the part of CNN commentators, apathy, and inability to string together a series of common legal principles. He also said not one commentator reflected on whether Dershowitz's January 27th arguments on the law of impeachment regarding high crimes and misdemeanors would invalidate any of their commentary. And yet he ruled, because the law said he had to rule this way, he says, he ruled that I hadn't established actual malice, that although the commentators engaged in foolishness and apathy and an inability to string together a series of common legal principles, they didn't engage in actual malice, which is reckless disregard for the truth. Now, I have to tell you, I don't understand the difference between foolishness and recklessness, and I would think that's something that the jury should decide. And obviously, we're appealing the issue, and we're going to ask to have the jury decide whether the foolishness of CNN became recklessness, as I think they did. But at least the jury should be deciding that issue. So, mirror images. I'm suing CNN because I don't think CNN was just putting on a view that many people had. They were putting on their own views, which was a lie, a categorical lie, as the judge said. He said, Dershowitz said nothing of the kind. What to give you a clearer statement of that the people lied. Again, I don't want the judge deciding this case. I want the jury deciding this case. I want the jury to hear me. I want them to see the videotape. I wanted to see what I said on January 27th when I defended the president. I wanted them to see what I said when I responded to a question from two senators about whether or not quid pro quo is impeachable. And basically I said, yeah, it's impeachable if it's criminal or if it's illegal or unlawful or corrupt, but it's not impeachable if it's just motivated by desire by the person running to get reelected. Obvious point, but they distorted it into a president can do anything he wants, even commit crimes if he wants to get elected. The judge said, I said nothing of the sort. So it's very different than the Fox case, but the Fox case is a very, very serious case and a very, very important case. Will it be settled by the time you watch this? Maybe it's been settled. I don't know. It wasn't settled as of the time I started this show. It'll be hard for Fox to settle because it will make Fox really essentially admit that what they did was wrong. Now, of course, the settlement will say we don't admit that anything we did was wrong, but they'll have to pay a lot of money. And if they pay a lot of money, that constitutes an admission in the minds of some people. When I settled my case with my accuser, who then obviously said she may have misidentified me for somebody else, I didn't pay a single penny, and I never would under any circumstances. So, but in the Fox case, they will have to pay money, and I would like to see the Supreme Court get involved in this. Maybe they will in my case. Maybe they will. If Fox settles, that's the end. They won't get involved, and so we'll never have an answer to the core question. Whether a network like social media whether a network can put on the air information that it knows or believes is not true but that many, many people think it's true, and allow the viewer and the listener to make a decision for themselves. That, to me, is the way the First Amendment should operate. Again, distinguished from my situation where obviously they all knew without any doubt that I didn't see anything, as the judge said, anything like that, anything of the kind, and they turned my statement into exactly the opposite of what I had said. So my case may be the one that gets up to the Supreme Court if the Fox case settles, and I will bring my case all the way up to the Supreme Court, looking for an opportunity. You know, it's ironic because I was one of the law clerks on New York Times versus Sullivan back um, in the early 1960s when I was clerking for Justice Goldberg. And although my co-clerk had primary responsibility for the work done on New York Times versus Sullivan, I participated actively in the drafting of Justice Goldberg's concurring opinion, in which he agreed with some and disagreed with others. My own view today is that networks have too much of a license to lie today, and they can hide behind the actual malice requirement, and that has to be adapted to the realities of modern day thinking. And a number of the justices have already said they agree with that. And so we'll wait and see. We'll see. But you know, again, under the Seventh Amendment to the Constitution, all of these issues should be decided by juries. That's the one place where my case and the Fox case are in complete agreement. Judges should not be making these decisions. The framers of the Constitution were suspicious of judges. Jefferson was more than suspicious of judges. Hamilton and Madison, they were suspicious of judges. And they wanted jurors to make these decisions, particularly decisions like actual malice, whether there's a difference between foolishness, apathy, and the inability to string a series of common legal principles together, and recklessness. It seems to me that when you say somebody did something that's foolish, apathetic, and an inability to string together a series of common legal principles, that sounds to me like actual malice. It certainly sounds to me at least like the judge should have allowed the jury to make the decision about whether that constitutes actual malice. That's the argument we'll be making on appeal. And, you know, nobody can ever predict the outcome of an appeal, but I think the law should require these issues to be decided by juries, not judges. So we'll see what happens. We'll follow the case probably by tomorrow or Wednesday. We'll know whether the case is going to be settled. I'm rooting personally for the case not to be settled. I'd like to see some more definitive decision about whether or not networks could put this on. Because if there's a settlement, it will chill networks. It will prevent networks from actually putting on controversial views that they may themselves disagree with. And I think that the essential freedom of you and me to hear different views will be seriously compromised by that chilling effect. On my case against CNN, on the other hand, there's every good reason to chill and to prevent commentators from saying things that they know are totally untrue. Everybody on CNN knows that I never said a president who committed murder or other crimes can't be impeached. I spent my 67 minutes on the floor of the Senate saying exactly the opposite, for which I was criticized by CNN. And so, of course, they knew, and we'll see what the Court of Appeals has to say, and we'll see whether we have a settlement by tomorrow. I will report. You can stay tuned and know that you'll get up-to-date information on that and every other important legal issue that we face in these very, very traumatic and divisive times in America. Oh, one more point to make. If the shoe were on the other foot, if this were a lawsuit against CNN, that is, if the Fox case were against CNN or against the New York Times, you can be sure the ACLU and other civil liberties organizations would be on top of the case and would be expressing very, very strong views. But because it's Fox and because it's Trump and because it's the same get Trump mentality, about which I named my book, Get Trump, we see the lineup being very different. And that's America today. That's America today. In America today, the first decision is whose side are you on? If you're on Trump's side, we know which way you'll come out on civil liberties issues. If you're against Trump, we know what side you'll come out on the civil liberties issues. It's not the way the framers of our Constitution intended it, and it's not the way the rule of law um, is manifested in any fair society. The first test always has to be the shoe on the other foot test. What would the court decide? What would you decide if the politics were the opposite, but the facts were the same? That's the question I ask of every issue, and it's a question I ask you to ask of every issue. So let's turn to letters to me. Oh, the first one. Why is this leftist Marxist tool getting airtime? I've been accused of a lot of things, but a Marxist leftist tool. I have been against Marxism since the time I heard of Marx. Look, there is a kind of Marxism I favor, Groucho Marx. In fact, I have a sweatshirt that says, I'm still a Marxist Leninist, and it has a picture of Groucho Marx and John Lennon. I defended John Lennon, and I heard live Groucho Marx. I think it was in Carnegie Hall, one of his last performances. I'm a great fan of. So I am a Marxist, I admit it. I am a Groucho Marxist, I'm a Harpo Marxist, but I'm not a Karl Marxist, and I never have been. And for those of you who use that term just to describe anybody who you disagree with, if you disagree with me on anything, I'm a Marxist, I'm a leftist Marxist. That really is the old McCarthyism. So stop it. Professor, what legal issues will the rise of artificial intelligence create in America? Jonathan Turley has already been the victim of a false story generated by ChatGPT accusing him of sexual harassment of students. Well, you don't need artificial intelligence to be falsely accused of sexual misconduct. There wasn't a machine or anything artificial about the false accusations that were made against me. So, anything that can be done by artificial intelligence has already been done, I think, by human beings. So we do have to deal with false accusations, whether against Turley or against me, but I don't think artificial intelligence has much to do with it. Of course, artificial intelligence can create evidence where none exists. And I said from day one, there wouldn't be any real evidence of me doing anything wrong. And of course, none has come out. But, I can imagine in the future, people creating images or fake tape recordings or fake photographs. That's certainly possible, and the law ought to take into account that possibility in evaluating evidence. Alan, I enjoy your history lessons and legal analysis. In these things, you excel. Your political opinions, on the other hand, let's just say we politically disagree more than agree. But I respect your consistency and integrity. Those seem to be such rare traits these days, especially among Marxists and like me. Okay. Alan Dershowitz, thank you for producing this important show with your father. Please keep going, Professor Dershowitz and Alan. So let me take a moment to really express my thanks to Alan. The show would not be possible without him. He does all the hard work. I just do the easy work of talking. He does the production. He makes sure everything comes out right. And he corrects the inevitable glitches when they occur. He helps me pick subjects and topics. He helps me pick letters. He is the MVP of the show. And so I want to express my great thanks to my wonderful son, Alan, and thank you for commenting on him. This is from Marketing Guy. I don't know who it is. Mia. Well, whoever it is, thank you. I appreciate it. And I'm sure I speak for Alan when I say he appreciates it.
Thank you.
Professor Dershowitz, I think it's fair to say you have led a fascinating life. Netflix really should produce a documentary about it. Netflix has produced a documentary, and I sued them. Ultimately, we settled the lawsuit, but that was the documentary on which I was falsely accused, and they haven't made a correction yet. You'd think Netflix, if they were a decent platform, would have a little statement every time it shows that documentary saying, oh, and by the way, the woman who initially accused Dershowitz now says that she now recognizes she may have misidentified him. Just quote that statement. That's the least I think Netflix could do after completely defaming me and many others in the past. Okay. Are too many documents classified now? Or, in other words, does our government overclassify material? Does it matter in cases involving Trump, Biden, or Pence? Thank you. Of course, the government overclassifies. They've always overclassified. They also underclassify. There are occasions when they miss something that should have been classified, but the mistake that is most common is overclassification. They classify often not to protect national security, but to protect the reputation of individuals. We learned that in the Pentagon Papers case when Ellsberg gave the New York Times and Senator I can't remember his name now, Gravel of Alaska, the Pentagon Papers. I represented Senator Gravel in the Pentagon Papers case all the way up to the United States Supreme Court. So I'm very familiar with that case. And I gave some advice to Alex Bickle, the man who argued the case in the Supreme Court. We had some work together because we were both representing different people in the Supreme Court. But I think all of us agreed that there was overclassification. And obviously, the Pentagon Papers proved that. The government, Solicitor General Griswold, stood in front of, I remember very vividly, stood in front of the 9 justices and said, if you allow the Pentagon Papers to come out, the national security of the United States will be compromised. And then, of course, they were let out. And there was almost nothing in there that compromised national security, but a lot of stuff that was very embarrassing to people that had been in the government over the years. And you could easily see why they classified this material to cover up their own inadequacy and their own mistakes. Okay. There is a saying among historians, I was a history major, it says, never learn history from a lawyer. You might be the exception to that saying. So no, the saying is correct. Don't learn history from a lawyer who's litigating a case, because a lawyer who's litigating a case is not a historian. The lawyer is an advocate, and the lawyer may very well wrench out of context. I didn't do that in the Trump case. I was very accurate in my rendition of history, but I was an advocate. And but when I'm on this show, I'm not an advocate, and so I'm not an exception to the rule. It's just that I'm performing a different function. I'm not being an advocate on this show. I am an advocate when I appear in court. So it's important to see the functions of lawyers differently, depending on what role they're playing. Thank you for mentioning handmade shmura matzahs and gefilte fish, but I had to stop with the horseradish. I got blown 10 feet back when I smeared it on. I recently gave a piece of gefilte fish to a friend of mine, and I included the horseradish, and he gave me the horseradish back. And I don't go near that stuff. Are you kidding? It's like diesel fuel. You got to have a taste for it. I have a taste for horseradish, so there it is. Do you think states and feds should have a law that says you cannot run on the platform of prosecuting an individual? Absolutely. Absolutely. And if not a rule of law, it should be a rule of ethics of the bar. And I don't think it would interfere with First Amendment rights. You can run on many issues. You can run on what kind of people you're going to prosecute. But you shouldn't be able to run by saying, if I am elected, I will prosecute A, B, C, D. That's the functional equivalent of like a bill of attainder, which is prohibited by the Constitution. You don't name individuals first, target them, and then try to rummage through the statutes and find something. That's what Justice Jackson said was wrong, and that's what Stalin and Lavrenti Beria said was right. Whose side are you on? I'm on Jackson's side. Okay, founding fathers and mothers of Israel, Golda Meir, Benjamin Netanyahu, Menachem Begin, David Ben-Gurion, Yitzhak Rabin. The book will be a happy read. Please write the book. I mentioned that I was thinking of writing a book on founding fathers and one Jewish mother. comparing the founders of Israel and the United States. Both were established in the name of freedom and democracy and being able to escape from oppression. And so I hope to have the strength, courage, and longevity to write that book. It's almost 85, so it's getting a little late in the game, but I'm going to try my best to get to 60. With my work in progress, I'm now at 64 books. I have 62 out there. My New McCarthyism book is in pretty good shape. And then I have a book called The Preventive State, that's 64. And then I have another book that I'm thinking about working on about religion. So that would be 54. 54. My son corrects me as usual. 54. So that would make it 55. And then I'd have another 5 books to write in the next, hopefully, years that the good Lord gives me, with the ability to think and the ability to write and the ability to continue to work at the level I'm working at. So looking forward to seeing you tomorrow and looking forward to getting your letters. Good night.